The Constitution of Austria 1920, Provisions on Treaty. Article 9, 1. The generally recognized rules of international law are regarded as integral parts of federal law. 2. By law or state treaty having been approved according to Article 50 para may first transferred specific federal competences to other states or intergovernmental organizations. The same way the activity of agents of foreign states or intergovernmental organizations inside Austria and the activity of Austrian agents abroad may be regulated, as well as the transfer of single federal competences of other states or intergovernmental organizations to Austrian agents, be provided for. Within this frame it may be provided for that Austrian agents shall be subject to the authority of agents of other states or intergovernmental organizations, or such be subject to the authority of Austrian agents. Article 10, 3. The Federation must allow the lender opportunity to present their views before its conclusion of treaties which within the meaning of Article 16 render necessary enabling measures or affect the autonomous sphere of competence of the lender in another way. Is the Federation in possession of a uniform comment by the lender, the Federation is bound thereby when concluding the state treaty. It may deviate therefrom only for compelling foreign policy reasons. The Federation must advise the lender of these reasons without delay. Article 13, 2. State treaties changing the federal boundaries may only be concluded with the approval of the lender affected. Article 16, 1. In matters within their own sphere of competence, the lender can conclude treaties with states, or their constituent states, bordering on Austria. 2. The governor must inform the federal government before the initiation of negotiations about such a treaty. The federal government's approval must be obtained by the governor before their conclusion. The approval is deemed to have been given if the federal government has not within 8 weeks from the day that the request for approval has reached the federal chancellery told the governor that approval is withheld. The authorization to initiate negotiations and to conclude the treaty is incumbent on the federal president after the recommendation of the land government and with the counter-signature of the governor. Article 23, I, 1. The Austrian member in the European Council may agree to an initiative according to Article 8 para 7 of the Treaty on the European Union as amended by the Lisbon Agreement only having been authorized by the National Council, with the approval of the Federal Council. On the basis of a proposal of the federal government. Such resolutions of the National Council and the Federal Council each require the presence of at least of the half of the number of members and a majority of 2/3 of the votes cast. Article 23J. Austria participates in the common foreign and security policy of the European Union on the basis of Title V, Chapter 1 and 2 of the Treaty on the European Union, as amended by the Lisbon Agreement, which provides in Article 3 para 5 and in Article 21 para 1 especially the observance of respect for the principles of the Charter of the United Nations. This includes the participation in duties according to Article 43 para 1 of this contract and in measures by which the economic and financial relations to one or several third countries are suspended, restricted or completely severed. Article 50 para 4 is to be applied accordingly to resolutions of the European Council concerning a common defense. 3. The right of vote concerning resolutions on the start of a mission out of the European Union, the tasks of military consultation and support, tasks of conflict prevention and maintaining peace or combat operations in the frame of crisis management, including peacemaking measures and operations to stabilize the situation after conflicts, as well as on decisions under Article 42 para 2 of the Treaty on the European Union, as amended by the Treaty of Lisbon concerning the step-by-step determination of a joint defense policy, is to be exerted by coordination between the Federal Chancellor and the Minister competent for foreign relations. Article 49, 2. The state treaties according to Article 50 Para 1 are to be published by the Federal Chancellor in the Federal Law Gazette. In case a state treaty according to Article 50 Para 1 Subpara 1 has been laid down in more than 2 languages authentically, it is sufficient if 1. 2 authentic language versions and a translation into the German language. 2. If, however, the German language version is authentic, such and a further authentic language version are published. The National Council can on the occasion of the approval of state treaties pursuant to Article 50 Para 1 resolve in which other way than in the Federal Law Gazette the publication of the state treaty or single parts exactly to be specified shall take place. Such resolutions of the Federal Council are to be published by the Federal Chancellor in the Federal Law Gazette, unless explicitly provided otherwise. State treaties according to Article 50 Para 1 enter into force upon expiry of the day of its publication in the case of the third phrase upon expiry of the date of proclamation of the resolution of the National Council and extend to the entire federal territory. This does not apply to state treaties to be implemented by passing laws. Article 50 Para 2 Subpara 4. Article 50, 1. The conclusion of 1. Political state treaties and state treaties the contents of which modify or complement existent laws and do not fall under Article 16 Para 1, as well as 2. State treaties by which the contractual bases of the European Union are modified, require the approval of the National Council. 2. To state treaties according to Para 1 Subpara 1 additionally, the following applies. 1. In case a state treaty provides its simplified modification, such modification does not require approval according to Para 1, unless the National Council has reserved such approval. 2. To the extent a state treaty settles matters falling within the autonomous sphere of competence of the lender, it requires the approval by the Federal Council. 3. In case a state treaty has been laid down authentically in more than 2 languages, it is sufficient, if the approval under Para 1 is granted, a. on the basis of 2 authentic language versions and a translation into the German language, b. if, however, the German language version is authentic, on the basis of such and a further authentic language version. 4. At the time of approval of a state treaty, the National Council can resolve to which extent the treaty in question shall be implemented by the issue of laws. 4. Notwithstanding Article 44 Para 3 state treaties according to Para 1 Subpara may second only be concluded with the approval of the National Council and the approval of the Federal Council. These resolutions each require the presence of at least half of its members and the majority of 2/3 of the votes cast. Article 65, 1. The Federal President represents the Republic internationally, receives and accredits envoys, sanctions the appointment of foreign consuls, appoints the consular representatives of the Republic abroad and concludes state treaties. Upon the conclusion of a state treaty not falling under Article 50 or a state treaty pursuant to Article 16 Para 1 which neither modifies nor complements existent laws, he can direct that the treaty in question shall be implemented by the issue of ordinances. Article 66, 2. The Federal President can authorize the federal government or the competent members of the federal government to conclude certain categories of state treaties, which neither fall under Article 16 Para 1 nor under Article 50. Such an authorization extends also to the power to order that these treaties shall be implemented by the issue of ordinances. 3. The Federal President can on the recommendation of a land government and with the countersignature of the Governor authorize the land government to conclude treaties in accordance with Article 16 Para 1 when they neither modify nor complement existing laws. Such an authorization extends also to the power to direct that these treaties shall be implemented by the issue of ordinances. Article 89, 1. save as otherwise provided by the following paragraphs, the courts of justice are not entitled to examine the validity of duly published ordinances, proclamations on the republication of a law, state treaty, laws, and state treaties. 2. In cases where a general court has doubts concerning the use of an ordinance based on illegality, an announcement about the republication of a law, state treaty, because of illegality, a law based on unconstitutionality, or a state treaty because of illegality, it must file a petition for the repeal of this legal provision at the Constitutional Court. Article 139A. The Constitutional Court pronounces on the illegality of pronouncements on the republication of a law, state treaty. Article 139 is to be applied accordingly. Article 140A. 1. A state treaty of which the Constitutional Court establishes that it is contrary to law or unconstitutional shall not be applied any more by the authorities competent for its execution from the expiry of the day of the judgment's publication unless the Constitutional Court determines a deadline prior to which the state treaty shall continue to be applied. Such deadline must not exceed 2 years for the political, law-modifying and law-amending state treaties and the state treaties modifying the contractual bases of the European Union and 1 year in the case of all other state treaties. 2. In addition, a provision that the state treaty is to be implemented by issuing ordinances or a resolution, that the state treaty is to be implemented by the issuance of laws, becomes ineffective upon expiration of the day of the judgment's publication. Article 144. 1. The Constitutional Court pronounces on rulings by an administrative court insofar as the appellant alleges an infringement by the ruling of a constitutionally guaranteed right or on the score of an illegal ordinance. An illegal pronouncement on the republication of a law, state treaty, an unconstitutional law, or an unlawful treaty. Article 149. 1. In addition to the present law, the following laws, with the modifications necessitated by this law, shall within the meaning of Article 44 para 1 be regarded as constitutional law, Section 5 of Part 3 of the Treaty of Saint-Germain of 10. September 1919, STGBL. Subpara 303 of 1920. Article 151, 11. 2. The heading of Chapter 1, the heading of Section A in Chapter 1, Article 10 Para 1 Subpara 18, Article 16 Para 4, Section B of Chapter 1, Article 30 Para 3, Article 59, Article 73 Para 2, Article 117 Para 2, Article 141 Paras 1 and 2. Article 142 Para 2 Subpara C and designations of the henceforth subparas D to I as well as Article 142 Paras 3 to 5 enter into force simultaneously with the Treaty on the accession of the Republic of Austria to the European Union. 19. Article 23F enters into force simultaneously with the Treaty of Nice. The Federal Chancellor shall announce this date in the Federal Law Gazette.